Good afternoon. Welcome. Um, Welcome to our National Grid Senior LEAP program. My name is Joanne Reese. I'm the family law staff attorney with the Brooklyn Bar Association Volunteer Lawyers Project, also known as the VLP. Our office is located downtown Brooklyn at 44 Court Street. Currently, we all are working safely from home. So thank you for joining us this way remotely. We're still trying to, have our programs and doing it the best way we can. So thank you for joining us remotely. A little bit about the VLP. So we provide free legal services to Brooklyn residents living at or below the federal poverty guidelines. Our office has been providing services for about 30 years. We made 30 years last year, so we're really proud of that. We provide free services in several areas of law. Our main practice areas are, we have a foreclosure prevention unit. We assist homeowners in Brooklyn facing possible foreclosure. We have a consumer debt practice. We assist those being sued by creditors, mainly in Kings County Civil Court. We have a Chapter 7 bankruptcy practice. We assist people seeking a fresh start. A family law practice, which is my area. We handle custody, child support cases, paternity cases pending in Kings County Family Court. We also have a pro se assistance for uncontested divorce actions. We have an Article 17 guardianship program where we assist caregivers seeking to gain guardianship over intellectually or developmentally disabled adults. And last but not least, our elder law practice, an office, often it's seniors, but our services are available for people of all ages. They can benefit from our practice. And we provide direct assistance by assigning an attorney to assist with advance directives. So whether it's a healthcare proxy, power of attorney, or will, which is why we're here today, we will assign an attorney, pro bono attorney, to assist anyone who qualifies and who are looking for those services. So part of our elder law program, our National Grid Senior LEAP program, we like to educate Brooklyn communities. Pre-pandemic, we used to go to the various senior centers or meeting places and go in person to discuss the importance of advance directives. Now we're here to do that remotely. So let's just get started. The importance of advance directives. So what are advance directives, right? Basically, directives are your instructions, and these are instructions regarding your medical wishes and directions or instructions regarding your financial affairs. Advance directives are legal documents that allow you to appoint a surrogate decision maker, an agent to make decisions for you if you are unable to make your own decisions regarding your medical care. So healthcare proxies and living wills are advance directives that deal with healthcare decision making. Then there's durable power of attorney, and those are directives that allow someone else to act as your agent to make financial decisions for you. These are extremely important documents that allow us to plan ahead in the event that we later lose the ability to make our own decisions. New York health law allows all competent adults, so that's people over the age of 18, to sign a healthcare proxy. This form gives the person you choose, your agent or your surrogate, the authority to make all healthcare decisions for you. Healthcare decisions can include to remove or to provide life-sustaining treatment, and this is unless you specifies otherwise. Healthcare decisions are any treatment, services, procedures that will diagnose or treat any physical or mental condition. In order for your agent to make decisions about artificial nutrition and hydration, such as nourishment and water by a feeding tube or an IV, your agent must know your wishes. So that it must be specific about those decisions, about your wishes. And that can be indicated on the form. If they do not know your wishes, then they cannot refuse to consent to such measures. If you name an agent by filling out a healthcare proxy form, your agent will start making decisions for you when your doctor determines that you are unable to make decisions for yourself. No one can make healthcare decisions for you while you have the ability to do so. If you are able to communicate or able to indicate your wishes to your doctor, then your wishes should be followed. You can indicate on your healthcare proxy form what type of treatments you would want to receive, treatments you would not want, and under what circumstances. This can be a guide for your agent. It can be a guide for your medical provider. In the event your agent is not available at that time, it can provide, the document can limit limitations on your agent's decision-making powers if you desire. So you can decide exactly what decisions your treatment, what your wishes are, and your agent will express those wishes to your treating physicians. Now, you can express your wishes or your instructions regarding organ and tissue donations as well. You can specify, if you choose, what organs or tissues you wish to be used for transplantation or research purposes or educational purposes. If you choose not to fill out this option on your healthcare proxy form, that doesn't mean you will not be considered for donation, but providers generally will look to your agent for guidance if they know what your wishes are. Generally, agents' powers terminate upon death, right? But however, this is one area where the agent may still be able to make decisions on your behalf if you pass away. So organ donation is that exception where your agent can still make such decisions if and only if they know your wishes, your wants, and your preferences. If no agent, if you don't have an agent and you don't have a healthcare proxy form, generally medical providers will look to your next of kin. There's certain family members that can consent on your behalf, and that, you know, they would look generally to your spouse first, your adult children. If no spouse or adult children, then they would look to one's parent. And if there are no spouse, no children or a parent, then they would look to a sibling, and they go in that order. So generally, your next of kin will be able to consent to organ or tissue donation if they know what your wishes would be. Now, you do not necessarily need an attorney to complete a healthcare proxy form, but an attorney can be helpful. An attorney can explain the role of your agent. They can make sure it's filled out properly. They can answer any questions or concerns you may have. The form it's not required to be notarized. You do need, however, to have 2 adult witnesses present when you sign your healthcare proxy form. The person named as your agent or your alternate or substitute cannot be the person named as a witness. So you would just need another adult, someone that is not named as your agent or a substitute to be a witness to the signing of your healthcare proxy form. So who can be an agent? Who should you choose? Any adult, anyone over the age of 18, family member, close friends, someone you trust. You cannot name more than one person as your healthcare proxy agent. You can, however, name an alternate or substitute person to act as your agent in the event the first person you named, your principal, is unable or unwilling or unavailable to act on your behalf. Your doctor may be your agent, but then you would have to decide whether or not he or she will continue to be your treating physician. So you would decide whether you want them to be continue to be your treating physician, or whether or not you want them to have the powers to be your agent. They can't do both at the same time. So that's something you would want to discuss with your physician and decide what makes the most sense for you. Most importantly, you must discuss with your agent beforehand your wants. This requires a frank conversation. You want to discuss whether they are willing and capable of acting as your agent. You want to make sure that they are aware of your wishes, whether it's based on your religious beliefs, your spiritual beliefs, or your moral beliefs. They want to basically act They want to be able to act as if they were you. They want to know what you wish. You want them to know what your wishes are, so they can inform your physician what you would wish. You would want to discuss whether or not you would want certain treatments, whether or not you would want to remain on life support if you were in a coma, or whether or not you would want certain treatments if you had a terminal illness, whether you would want artificial nutrition and hydration, and under what circumstances you would want these things. These can be very difficult things to think about, let alone discuss with others, but it is important. It allows you to make decisions for yourself when you are no longer able to express your wishes. Now, if your spouse is named as your agent and you later become divorced or legally separated, by law, they will no longer be your agent. So the healthcare proxy terminates. However, you can still name them. What you would want to do is just fill out a new updated form naming your former spouse as your agent. Okay, so just to be clear, so if your spouse is your agent and then you become divorced, that form basically terminates and their powers as your agent terminates by law, and you just want to execute a new one naming your former spouse. You want to make sure you have a few copies of your healthcare proxy form, right? So you would want maybe to have to give a copy to your medical provider. Obviously, you would want to make sure your named agent has a copy, possibly a family member or a neighbor should have a copy in the event of an emergency. This is not the type of document you keep hidden, locked in a safe. You want it to be accessible. You keep a copy in your purse or your wallet. It's on your refrigerator in case of an emergency. If emergency medical personnel have to come to the home and you're unable to communicate. You have a copy with you if you're going to the hospital, even if it's for a minor procedure or surgery. You just want to have it just in case. If you're traveling, going on vacation, you would want to have a copy with you, just in case in the event there's an emergency. They have a way of communicating with your agent, knowing exactly who they should speak to if you are unable to communicate. So the key is to have it accessible, right? You want to make sure that people know where the form is and that they have access to it. So it's important also to know that you can revoke or cancel your agent's authority at any time. You simply would tell the agent, for whatever reason you choose, why you no longer need them to be your agent. You would tell the treating doctor or your medical provider, verbally or in writing. Ideally, what you would do is anyone that had a copy of the prior form, you would want to make sure that they're aware that that person is no longer your agent, and you would hopefully execute a new form, so that way you're not left without a named agent in case there's an emergency. And you would want to destroy any of the prior copies and just execute a new one. Appointing a healthcare agent is a voluntary choice. No one can require you to appoint them. Again, this is something that you should decide based on what makes the most sense for you, who you trust, who you know is willing to act on your behalf, who you know you have spoken to and that they are well aware of your beliefs, whether it's, as I said, religious or spiritual or moral beliefs, and what kind of treatments you would want and under what circumstances. Why should you choose a healthcare agent? Well, if you become unable, even temporarily, to make healthcare decisions for yourself, someone else must decide for you. And having a healthcare proxy form allows you to have control over who that is. It allows you to maintain control over your medical treatment when you're unable to communicate yourself. So by naming someone, they will act as you would wish. Often medical providers look to family members for guidance. Appointing an agent can avoid confusion or conflict among family members. If you have more than, if you have 2 or 3 children and, they are in disagreement of how they should care for mom or dad and what mom and dad would want, by you naming one person, it gives them the authority, and it can alleviate, lessen the burden for loved ones. It can avoid that conflict or that confusion. during these difficult times. Often can be very difficult for family members. Appointing a healthcare agent is a good idea, even if you're not elderly. This isn't something just for seniors, right? An agent can act on your behalf, even if it's a temporary condition. So for instance, if someone's having a procedure and they're going under anesthesia, or they're in a medical induced coma, or there was a brain injury from an accident, or even impacted by COVID-19 pandemic. We have seen that the pandemic can affect people of all ages. So anyone can have, it's a good idea for anyone of all ages to have a healthcare proxy form and naming an agent in the event that they are unable to communicate, even if it's temporary. And remember, once you're able to make your own decisions, and once that temporary condition passes, then the agent no longer has to act on your behalf, and you will be able to communicate and make the decisions yourself. So it's a good idea to have just in case of an emergency. Next thing I want to talk about is a living will. So what we just discussed, a healthcare proxy form, and that's naming an agent. A living will is another type of advanced medical directive, and this is generally used when recovery is not likely, where the person is in a permanent or vegetative state. And a living will is a legal document that spells out your wishes regarding your medical care in the event you become incapacitated. You're unable to express your wishes, and you're unable to make medical related decisions for yourself, and you're not likely to recover, then the living will can be referred to. So if someone doesn't have an agent, if they don't have a healthcare proxy form filled out, a living will can be used as a guide to medical providers when you're unable to communicate. You can specify what treatment you would want and what you would not want to be kept alive. You can specify your preference for pain management, organ or tissue donation. It's a legal document that allows you to maintain control over your care when you become incapacitated. A living will versus a healthcare proxy. So a living will is the document itself provides the guidance when the condition is likely permanent and recovery is unlikely. It provides instructions regarding your wishes if you are terminally ill or in a vegetative state. Compared to a healthcare proxy, the agent, the person you name, acts on your behalf. The person you name communicates your wishes to the medical provider. Now, technically, a person can have both, that you can have both living will and have a healthcare proxy, a named agent. But naming an agent in your healthcare proxy allows you to, for them to act on your behalf for unforeseen circumstances, possible events that wasn't specified or considered in your living will. Ideally, your agent will be able to act on those unforeseen events and be able to advise your medical doctors how you want to be treated, because they know your wishes and your general overall moral beliefs, religious beliefs, and spiritual beliefs on how you would want to be treated under those circumstances. But if you don't have a healthcare proxy agent, if you don't have a healthcare proxy naming an agent, then a living will is another option that can provide guidance to your medical providers in the event you were incapacitated and you're not likely to recover. But again, technically you can have both, but you would want to make sure the two do not conflict with each other. So basically, you would want your agent to be on the same page as the living will and make sure there's no conflict of what you told your agent versus what is outlined in your living will. So those were the advanced directives regarding medical care. Just to recap, healthcare proxy and living wills. That deals specifically with medical decisions. Now I would like to discuss another type of advanced directive, and that is power of attorney. And this is advanced directives for your financial matters. Generally, there are two types. So most common is a durable power of attorney. This becomes effective as soon as it's signed, versus another type, which is called a springing power of attorney, which is effective at a future time, usually upon your incapacity. It requires you to indicate an event or condition when your agent's powers would would come into an effect. It also requires you to say who can determine if you're no longer able to make decisions. And just a reminder, these are financial decisions, non-medical decisions for yourself. Unless you specify otherwise, your regular treating physician will make that determination to determine when you are no longer able to make decisions for yourself. Both powers, whether it's a durable power of attorney or a springing power of attorney, terminate upon your death. Both types will empower someone to manage your financial affairs. So pay your bills if you're unable to do so. They can address any legal action that might be pending against you. They can buy and sell your property. Basically, they can handle all of your non-medical business and financial affairs as if they were you. Having a power of attorney properly filled out allows you to decide in advance who will make your financial decisions if you become unable to act for yourself. New York State has a statutory form, so there's been new changes as of just this month, June 13th, I believe. There's been an update to the law in regards to power of attorneys. And basically, it's almost in response to the pandemic and the need that was determined for power of attorney. So the main changes that have come into effect after June 13th of this year, the substantial conformity standards. So basically, the old forms are often can be considered too complex and difficult for individuals to use. So for instance, residents of nursing homes or long-term facilities found it hard to fill out the power of attorney during the pandemic. If there wasn't an attorney to advise them, if there wasn't an attorney present or available, it could be difficult if someone's not familiar with the form. The old form required a very rigid use of certain language and very specific wording, and that often led to invalidating healthcare power of attorneys for harmless errors. Just because it didn't use the exact language, it would invalidate the form, and therefore someone would be without that power of attorney. So the new law tried to address these issues, and the new law kind of it no longer requires it to be strictly rigid use of the language, and now what it says is that it substantially should conform. So instead of being very strict about the language, they kind of loosened those restrictions, and it kind of basically it validates more forms than not. It also, the new changes eliminated what was a statutory gift writer. So the new law allows the principal to authorize gifts in the power of attorney form itself. Before, there was a gift writer that had to be filled out for your agent to have the power to give gifts either to themselves, family members, or what have you. And it was meant, the old way was meant to kind of reduce abuse and fraud in their gifting duties, but it often led to confusion. So the new law kind of does away with that and allows that gifting powers to be in the same form. So it's a little more streamlined. They also address the issues of, they put consequences. So there's penalties for unreasonable refusal to accept a valid power of attorney. So there will be consequences when recipients unreasonably refuse a power of attorney. So for instance, if a banking institution doesn't accept your form and it requires that their own form to be filled out, that could lead to delays, it could lead to issues, it could lead to people being without that protection of having that agent act on their behalf. So the new law discourages banks and financial institutions from improperly refusing valid power of attorneys, and it imposes penalties, and they could even face attorney fees. So it basically encourages anyone who receives a power of attorney to not refuse it unreasonably. There's also the last thing that has changed with the new laws this month is that it it's called like a safe harbor for third parties acting in good faith. So basically, if a recipient receives a power of attorney and they act on that power of attorney, and they didn't have reason to believe that it was fraudulent or invalid for whatever reason, then they will be shielded from any liability. So if they acted in good faith, then they won't face any penalties or any consequence in acting in good faith if it later turns out, for whatever reason, that power of attorney wasn't valid. Okay, so those are just some updated changes that kind of makes the forms a bit user-friendly, a bit more streamlined, less confusing for people, and it just allows them to be accepted more than readily rejected. So the specific requirements that are outlined in the statute, they have what's called a short form, and this lists specific powers that you may or may not grant to your agent. Basically, the short form outlines, probably has about 20 different transactions or matters that can be granted. So for instance, on the short form, it will say real estate transactions, banking transactions, chattel and good transactions, tax matters. So a person filling out a power of attorney will indicate, based on the short form, what powers they want to give to their agent. And they would initial and indicate out of the list of different transactions and matters what makes the most sense for their agent to have the power to handle. Okay, the form also begins with cautionary language because it's an important reminder. The power of attorney is such a powerful tool. It's very useful. It can be very helpful, but unfortunately, it's at risk of being misused or abused. Your agent may not, so it will remind the person who's filling out the power of attorney that your agent cannot make healthcare decisions under your power of attorney. So just a reminder, in New York, you would need a healthcare proxy, an agent to make medical related decisions, and then you would need a power of attorney, an agent to make financial related decisions on your behalf. Similar to a healthcare proxy, a power of attorney, the principal is the person you're giving the power to. Unlike a healthcare proxy, with a power of attorney, you can name more than one person to act as your agent. Now, you will have to decide if you want them to act independently, meaning separately, or if you want them to act together, meaning jointly. If you do not specify and you name more than one agent, they will be required to act jointly on your behalf. Now, there are advantages and disadvantages, pros and cons to appointing more than one agent. So for instance, advantage, a pro for having them work jointly, it can act as a safeguard against misuse of the power. They can check on each other. They will be made aware of the actions, what the other one is doing, and they can assist each other that way. Disadvantage or a con of having them work jointly is that it may cause delays in managing your affairs if they can't agree or if they're not available at the same time. So that could lead to delays. Now, if your agent works separately, if you name two people and they're working separately, well, the advantage is that the risk of delays is not there, as if they were working jointly. But the disadvantage would be that working separately may lead to a lack of communication. Potentially, they could work in opposition of each other. For example, if you have two people working separately and they both trying to sell or buy a piece of property from two different buyers or two different sellers. So, there's pros and cons, and you would have to decide what makes the most sense for you based on your needs. So choosing a responsible agent is the most important thing. Who should I appoint? Well, what we often say is someone you trust 1,000%, a family member, a close friend, a neighbor. It does not have to be a family member. It does not have to be your child. It does not have to be your spouse. It could be someone you feel most comfortable with, someone you know who will act in your best interest. A power of attorney can provide very broad powers if you give them that authority. It's almost like a blank check. So you want to make sure the person is willing, reliable, capable. You want to make sure that they can manage their own affairs. I often tell people, if you have 2 adult children and you can't decide who should have power of attorney over you, it's the child that can balance their own checkbook. This your child that pays their own bills on time and that is responsible with their own financial affairs. Then that's probably the better choice than your child that, is late paying their bills, that seems who's disorganized or who's not capable of handling their own financial affairs. So you want to make common sense choices about who should be named with your power of attorney to give that power to. Like a healthcare proxy, no one can make you name them as an agent. You should not feel pressure into naming them. You should not be coerced or forced into filling out a power of attorney naming someone. Sometimes family members or loved ones with good intentions may encourage you to name them as a power of attorney. But again, the choice is still yours. The choice remains with you. It is completely your decision, only can be made while you have the capacity to do so. You must be able to understand who you're giving the power to. What powers are you giving them to? You must be able to communicate that. Once someone's capacity is at issue, for instance, if they're suffering from dementia or Alzheimer's, is unable to communicate who they want the power to go to, or if they're unclear of what power they're giving them, if there's any doubts about their capacity to understand, then it's likely too late to execute this legal document. Our office, we receive calls, and these are calls from well-intended family members who are looking out for their loved ones, and they'll say something like, I want to get power of attorney over my mom. We need to get power of attorney for my dad. And I might say, well, what is your mother's condition? Can your mother call us, or can your dad call us? And they say, no, she's suffering from dementia, or no, she's unable to communicate. She has memory loss. Well, unfortunately, then I have to explain to this loved one that it's too late to have a power of attorney executed. Because generally it requires the person who wants to give the power to a loved one or family member, they have to be able to communicate. It's their request. They would call us and say, I want to give power of attorney to my daughter. Can you help me? If they're unable to do that, it's generally too late. So monitoring your agent, who's going to watch over your agent to make sure they're doing the right thing? As long as you are capable and you have the capacity to make your own legal decision, you can direct your agent and closely follow what he or she is doing on your behalf. Your agent is not your boss. They cannot make you do something you do not want to do. Your agent is required to act on your best interests and not their own. There's no court or government agency that will oversee automatically or monitor your agent's actions. But you can require your agent to maintain proper record keeping for all the actions they have taken on your behalf. You can require your agent to submit periodic records to be reviewed. For example, at the end of the month, you have your agent provide you with a copy of all the bills that they paid on your behalf. Or at the end of every 2 months, they have to give you all the transactions that they took care of on your behalf, just to make sure that things are being handled properly and nothing's falling through the cracks. You could require your agent to provide these records to a third party. So if to have a kind of a checks and balance, you can tell your agent at the end of each month, please send a copy of all the bills that were paid to this third party, to my cousin, to my neighbor, to my adult son. And this acts as a safeguard to protect your interests. So as I said, while the court is not regularly monitoring your agent, the court will get involved if it's requested. So the court can revoke a power of attorney if the agent is thought to be abusing their authority. So this generally requires a loved one, a concerned family member or friend, that believes that your agent is not acting in your best interest, they would have to file a petition seeking for the court to revoke the agent as your power of attorney. You decide what you want your agent to do or not do. And this is done by signing and initialing the form, as I outlined that the examples of the different transactions that can be available. As I said, you can limit your agent's powers. For instance, you can authorize your agent only to have the authority over specific accounts or specific financial institutions or transactions. You would only grant powers to your agent that makes sense, that meets your needs. So if you don't have any real estate, then you wouldn't give them the authority to make transactions over real estate. You could grant your agent the gifting powers, and that may include gifts to themselves if your agent is your spouse or your child. New York power of attorney forms allow you to appoint an alternate or substitute agent, similar to a healthcare proxy. So you can name an alternative trusted person that would be your agent in the event your first named agent, your principal, is unable or unwilling to act on your behalf. So revoking or termination of this important power. Power of attorney can be revoked if you change your mind at any time for whatever reason, as long as you have the capacity to make your own decisions. If you are unhappy or for whatever reason, you can revoke the agent's powers. If you can no longer make decisions, if you're no longer able to communicate for yourself, then a third party would likely have to seek court intervention to have that agent removed. Revocation should be in writing, similar to the form that was used to grant the powers. You would want to notify the party that they are no longer your named agent. You would definitely want to notify any banking institutions or financial institutions or any transactions that was done. You would want to let them know that that person is no longer your agent. So for instance, if your agent took care of your banking needs at Chase Bank and they were able to make deposits and withdrawals from your Chase Bank account, then you would want to notify Chase Bank that that named agent is no longer your agent. Ideally, what you would do is you want to make sure you signed a new power of attorney naming another trusted agent. So that way you're not without protection and there's no gap of time. So the form itself, just to recap, once you enter your name and your agent's name and address, and then you decide if you name more than one agent, if they are going to act separately or jointly, you would indicate and initial all the relevant powers to be granted to your agent. You would provide names and addresses for an alternate or substitute agent if you choose. The power of attorney must be signed in front of a notary, so that's different than a healthcare proxy, which required the use of witnesses. You only are required to sign one copy, but it's helpful to have two originals, and you would want to keep one for yourself and make sure your agent has a copy. Generally, a power of attorney is not required to be filed in the court unless it's regarding real estate transactions. Once a power of attorney is filed, a certified copy can be obtained by the county clerk's office if you needed a future copy. If the power is later revoked for whatever reason, and you did file a previous copy in the court, then you'd want to make sure you notify them with the revocation and that they are aware that that prior power of attorney has been terminated. Similar to a healthcare proxy, you are not required to consult with an attorney, but an attorney can be very helpful in filling out these documents. An attorney can counsel you about the powers that are appropriate, that makes the most sense for your situation. It can include any additional language or any powers to the statutory form that's appropriate for your needs. An attorney can advise you on your choice of agents or agents. The attorney can educate you and your agents about the agent's responsibilities. Most importantly, an agent can make sure your document is properly filled out, that it's signed voluntarily. So that means without any undue pressure or coercion from your from your agent. Okay, so it's worth repeating. A durable power of attorney is a very good thing when it's properly used, but it can be disastrous if it's misused. So never allow anyone to force you to sign a power of attorney. What happens if you do not have an advance directive, right? If you become incapacitated or your capacity is at issue and you cannot make your own decisions and you have not signed a power of attorney or a healthcare proxy naming an agent, well, then someone will have to petition a court for you. And that's generally through a guardianship petition, an Article 81, and that's done through the surrogates court. And this is someone that will be able to, a guardian over you would be able to make healthcare and financial decisions if the court grants them those powers. A guardianship requires legal papers to be filed with the court. The court will appoint a court evaluator. This is basically an investigative representative that informs the court and the judge. After hearing and speaking to all the parties, the judge decides who will make personal and financial decisions for you. Guardianship proceedings can be very time consuming. It could be costly. There are very few pro bono free legal services available. So for instance, my office, we handle guardianship 17A. We do not do guardianship 81. It's a different type of guardianship. And as I said, there are very few free legal services available. So therefore, someone will need, if they need assistance with this petition, they would need to hire, more likely than not, a private paid attorney to assist. Most important thing to remember about the importance of signing advance directives is do it while you still can, right? While you have the capacity to do so. You want to avoid the need, as I said, very often, very time consuming and expensive, the guardianship proceedings. You want to avoid that by filling out these forms while you have the ability to do so. It allows you to have a say in who can act on your behalf. It allows you to choose who can act on your behalf, and therefore the court does not have to decide. It allows you to maintain control, for you to have autonomy in the event you are no longer able to make your own decisions. So lastly, I want to talk about wills. Now, a will is a legal document that some of you may already have. Surprisingly, not everyone may need a will. Many people believe that a will determines how everything that a person owns will be distributed, but this actually is not correct. A will only determines who gets assets and property that are solely owned by the maker of the will. It's important to know that distribution of assets and property that are owned, jointly owned with a right of survivorship, so something that is owned with your spouse, or something that is designated for a specific beneficiary. So if you have CODs or some other bank accounts or some other life insurance policies that you already named a beneficiary, and those are things that are not passed in a will, or things that are held in trust. Those things that are not determined by the will. So things that are owned jointly, things that have already been designated to a specific beneficiary, or things that are held in trust are not determined by a will. So wills may be very simple, kind of relatively short, depending on the person's estate, or it can be very complex, a lengthy document. Again, it depends on the maker's needs. Whether it's a simple or complex will, all must be signed in front of a witness that have actually watched the will maker sign. Witnesses may sign an affidavit or a statement at that time that makes the will what's called self-proving, which avoids the need for the witnesses to be found later, just to make sure that the will was valid at the time, that the person signed it willingly and knowingly, and that it is in fact their will. And so that they don't have to look for witnesses once the maker passes away. So who must be named in a will? Well, except for a spouse, your legal spouse, who must receive a portion of your estate, everyone else receiving an inheritance is a privilege and not a right. So there's a common misconception that you are required, that your children must inherit from your estate, and that's not true. Only your spouse must receive an portion. Everyone else, it's a privilege and not a right. So what happens if a person dies without a will? Well, some people believe that the state will just get the assets, and that's not usually true. There are many steps before it gets there. So the state law determines who receives those assets that would pass under a will. Remember, only assets that you own solely, that have not been previously designated to a beneficiary. So most of the time, the state will look to family members who would inherit if there is no will. So generally it goes to the person's spouse and their children are first. And then next would be their parents or siblings. And if there are no spouse or children, if there are no parents or siblings, then there would be a niece or nephews. And then if no niece or nephews, then finally first cousins once removed. And then if there are no first cousins, then cousins twice removed. And then after that list is exhausted, and only if there are no spouses, children, parents, siblings, nieces and nephews, first cousins and cousins twice removed, then only then will the estate pass to the state of New York. So what are the benefits of having a will? Well, it allows you to direct who will receive your assets. You can make specific gifts to specific people. You can make gifts to charities if you choose. You can name who would act as your executor of your estate, who's going to be in charge of your estate. You can leave assets in trust to someone instead of making an outright gift. Most importantly, and as you find the theme of today's program, is having a will allows you to plan for the distribution of your assets at your death. It allows you to have control of your assets and how they're distributed when you're no longer here. It allows you to say who would be in charge to make sure your wishes are being honored. In order to settle your estate, the executor, the person you named, must submit your will for probate, and that's sent to the surrogates court. The court will determine that this is in fact your last will and testament. Thereafter, your executor will have the authority to settle your estate. So to distribute the assets to those named to inherit. The surrogates court will supervise, requiring certain record keeping, inventory. The court can require receipts and acknowledgement from your beneficiaries they did in fact receive what they were supposed to, in accordance with your last will and testament, in accordance with your wishes. Okay, so just to recap, when it comes to advance directives are legal documents that one can fill out now while they have the capacity to do so, and it allows them to have a say when they no longer have the capacity to communicate, and when they are no longer, and in the case of a will, once they pass away, they still have a say as to how their property, assets, and their estate is basically distributed. And what I often like to remind people is that if you have these documents, you want to make sure that you do what I call an annual checkup, right? You want to review your documents. You want to make sure that they are in accordance with your wishes and that these are still your wishes. If you fill out a healthcare proxy, if you fill that out 3 years ago, you don't just want to leave it alone. You want to make sure that it's still in accordance with your wishes. What if your wishes have changed? What if at the time you filled out your healthcare proxy form, you expressed to your agent that you had strong beliefs against a blood transfusion, and now for whatever reason, your feelings have changed, and now you would want a blood transfusion, or you would want certain treatment, or you would not want certain treatment. You want to make sure that your document is up to date with your wishes. You want to make sure, importantly, that anyone who's named in your documents are still capable of acting on your behalf, still willing, still have the ability to do so. You want to make sure that their contact information is correct. When you fill out these documents, often people may change their phone number or change their address. So you want to make sure that it's up to date in the event that there's an emergency, so that way there's no delay in your care. You want to make sure that your treating physician has the most up-to-date information to contact your agent. And God forbid, if your agent is no longer around or capable, you want to just make sure you have someone, you name someone new that can do so if there wasn't an alternate agent name prior. Again, I can't stress this enough. You want to make sure you have an open and frank conversation. You want to discuss your wishes with your agent. You want to make sure that they are in line with your religious beliefs, if that has changed, or your spiritual beliefs, if that has changed, if your moral beliefs has changed. You want to make sure that your agent is well aware of your wishes, so that way they can inform your treating physician that that it's the most up-to-date views, and that they know that they are acting in accordance with your wishes. You want to, when it comes to your power of attorney, you want to make sure that your agent is still capable of acting in your best interest and that nothing has changed. So do an annual review. Review your will. You want to make sure that if anything has changed, if there's things that needed to be added to your will, you want to update that. So you want to do what I call an annual review, an annual checkup on these documents. Okay, so what I often tell people is their homework after this program, at a minimum, is to have a conversation with their loved ones, to make sure that they have that frank conversation, to make sure your loved ones know where these documents are located. As I said, they're only useful if they're accessible, if they can be found in the event of an emergency, in the event that you're unable to communicate. Our office, as I said, we provide free legal services to qualifying Brooklyn residents. And if for some reason someone does not qualify for our services, they can still reach out to us. We will provide a referral, give them information if there's another organization available, or if there's low-cost services available, if someone does not meet our financial guidelines. And I will give you our phone number right now, if you can grab a pen, to contact our office if you're looking for services. You can reach the VLP at 718-624-3894. Once again, that's 718-624-3894. I want to thank you for joining our program today. I'm just going to double check real quick to see if there's any questions. Okay, excellent. So in the chat, we have the phone number if you're looking for services. Generally, our intake hours are Tuesday through Thursday from 10 to 4. But if you happen to call on a Monday or Friday, that's fine. Just leave a message and give us an opportunity to call you back. We do have a wait list, but because as I said, we do provide free services to Brooklyn residents. So there are a lot of people who are in need. But if you qualify, we will put you on our wait list, and we will assign you an attorney free of charge if you qualify. So I see that there are no questions. Excellent. Okay, so I think we're going to wrap up. And again, I want to thank you for joining us for today's program. And you know how to reach us if you're looking for services. I encourage everyone to use this opportunity to discuss with their doctors, to discuss with their family members, to execute these important legal documents, and to reach out to our office if you have any questions. I see. Yes. So there's a question as whether or not can executor be a beneficiary? And yes, they can. Okay. So I kept this program pretty general and gave very good. I'm glad this was, if you found this informative. I kind of gave the broad strokes, but if you want more specifics and more specific, if you have specific questions to your particular needs, then an attorney can discuss that with you and give you the information you're looking for. And if it's something that we don't cover in our office, We will be more than happy to provide you with a referral to give you the information who could be better suited to provide you that. Okay, I want to thank you for joining us. I wish everyone to stay safe and healthy, and we're going to end the recording now. Thank you.